Hey, everybody. Thank you for joining us today. We may have Ben Neiburger joining us on the video feed as well. It's always nice to bring people together in person, but until we get through this pandemic, this will have to be the next best thing. For those of you who don't know me, my name is Alice Wood, and I joined DuPage Foundation, gosh, back at the end of last summer. Hey, Ben. After having served as an estate planning attorney for most of my career. Today, DuPage Foundation is bringing you a program that is near and dear to my heart, smart planning strategies for seniors. This is a topic that should be on everyone's mind, either because we are seniors, or we will be seniors, or there's seniors in our lives that we care about. Given that we're all living longer, again, this is something we should pay attention to, and seniors are going to be an important demographic for DuPage County. Unfortunately, this is also a vulnerable population. So in the spirit of an ounce of prevention is worth a pound of cure, we've brought together a panel of speakers who care deeply about protecting our aging population. The Honorable Robert Gibson is a presiding judge in DuPage County, he has covered the probate call and the guardianship call. He received his undergraduate degree from Notre Dame and his law degree from the University of Illinois. Also joining us is Ben Neiburger of Generation Law. Ben has a wealth of knowledge in the field of elder law. He's been named a super lawyer by Chicago Magazine for a number of years, and he received his undergraduate degree from U of I and his law degree from Chicago Kent. Also joining us is Mike Sitrick from DuPage Foundation. And Mike is the Vice President of Advancement, and he's also my boss, but since I'm about old enough to be his mom, I'm not sure who can tell who what to do, but anyway, Mike received his undergraduate degree from Millikan and his law degree from Loyola School of Law. So for those of you who don't know much about DuPage Foundation, this group has an incredible vision, and it's to raise the quality of life throughout DuPage County. And there's a mission to foster philanthropy and connect donors to area needs and build community partnerships. It's definitely my kind of place, and hopefully your kind of place too. Today, we are going to talk about a number of things, but when it comes to Mike's portion of this program, some of you may have heard that there's an unprecedented transfer of wealth coming down the pipeline. In fact, it's estimated to be $9 trillion is going to be transferred through estates over the next decade, which affords an opportunity to make meaningful change towards charities. Also, lots of opportunity to make mistakes. You know, this is such a staggering amount of money, and it kind of makes you think you better be nice to your parents if they're still living, because they have something to do with their estate plan. For those of us who are interested in charitable planning, Mike is going to talk about that at the end of our program, and the importance of leaving a charitable legacy. So today we're going to have Judge Gibson talk to us about the risks and pitfalls of poor planning from the bench. Ben is going to be batting cleanup to tell us how we can avoid those mistakes. And then Mike will be talking about how we can create an impact through charitable planning. There's also going to be a Q&A feature that's, you can use that anytime during the program. So as you have questions that come up, please feel free to use that feature. Since we know everyone is zoomed out, we're going to have to move things along at a pretty fast pace or we're going to lose you. So here we go. And to kick things off, we're going to talk to Judge Gibson about his observations from the bench about, again, the risks and pitfalls of poor planning. So Judge Gibson, you ready?
Yes.
Okay, great. So I have a few questions that I want to run by you because I think, you know, these are things that people will really value your insight and your experience from what you've seen. So having practiced for 27 years as a lawyer and now being on the bench for 11 years, and if my math is right, that would make you almost a senior citizen, right? Yeah.
2.
Yeah, we're all getting there. So this is good information for all of us. But you also must have a unique perspective from your view from the bench of, what's gone wrong. And sometimes I think we learn best from people who've made mistakes. Is there anything that you can share with us as far as those observations from the bench?
Well, the first thing is you have to have an estate plan. And it's surprising how many people don't. And even big asset, high income people, in the celebrity sphere. In our county, we had a probate estate for Muddy Waters, the blues singer and player, and it's gone on for decades. And that was a function of not having a complete estate plan. And we've heard about Prince, for instance, Minnesota not having an estate plan. I mean, you have people, obviously, here we're not talking about celebrities, but it's just kind of emblematic of the fact that people don't like to think about death, and they don't like to plan for it for a variety of reasons. And so the first thing is getting an estate plan. And then I think that after that, in general, kind of like we go to the doctor periodically for a checkup or a physical, it's important to do that with your estate plan. People die, people get sick, people become estranged, financial circumstances change, children or grandchildren who are young at one time may be adults and may know more about estate planning than the person making the estate plan. So there's a real need to review that periodically. And just as people don't like to do it in the first place, once they do it, the tendency is to put it in a drawer somewhere and then forget about it.
Do you have a feel for like how many people don't have an estate plan? Like what percentage of people fail to plan?
Well, I think it probably depends on demographics and depends on the economic circumstances. I would say in DuPage County, there's probably some pockets where there's a high percentage that do, but I've always been surprised at how many people don't. And sometimes it's people you wouldn't really expect. Percentage-wise, though, I would just be guessing.
Okay. I mean, another question I have for you is about financial fraud against the elderly. And it seems to, like I've read that that's the highest growing form of elder abuse is financial fraud. And that a lot of times it's people's own family members who are the perpetrators. Is that something you've experienced or witnessed from the bench?
Very often, because I did handle the guardianship call for almost 5 years and up until 6 months ago. And it was eye-opening. And, you know, the groundwork for how that can occur, we have people living more diverse locations than in years gone by and decades gone by. Tended to be families were located geographically close to each other. So children and grandchildren would check on parents or grandparents. And it could be the reverse too. It could be a grandparent or parent checking on others, children, grandchildren, or siblings. And I think as people have moved and you're not physically present, it kind of lays the groundwork for the potential for abuse, because the senior citizen may be isolated to some extent. Maybe they have phone conversations, or even Zoom or FaceTime, but there's something to be said for physical presence in somebody's residence, for instance, to notice things are a problem. You know, it could be physical problems in the residence, roof leaking, or, you know, hoarding, getting to kind of getting beyond the pale. And it could be numerous. We've had cases where there were 6 TVs in boxes sitting in the, you know, when you walk in the front door, you can see them, where some people becomes either big spenders because you can do it online, or they're getting calls from people inducing them to purchase goods or services that they don't need, or just getting access to their information, their financial information or passwords or accounts, to be able to commit financial fraud that way. So the first thing is, don't let yourself be isolated. And if you don't have family members, then try to get trusted advisors and friends, and look out for each other.
That's a great idea. I mean, that whole team approach makes so much sense, to have like a check and balance approach to it, so all the power isn't within one person.
Because usually you find that when people are financially exploited, they're isolated to some extent. And sometimes they're isolated because they're, quite frankly, difficult people. And, you know, they're not as amiable to be around. But even if the person is that way, there does need to be help. And whether it's, I think in the first case, it should be family help, then friend help, trusted advisor help, and then it's in some cases government help or not-for-profit help.
Well, it brings up another question, because in DuPage County, we have a public guardian and a public administrator. And so can you talk about their roles and how they can look out for senior citizens?
Yes. Well, we have a few good things in play. In terms of the public guardian, if a person needs a guardian, if a senior citizen needs a guardian, but there's no family members to step up, the DuPage County Public Guardian can fit the bill, and they do a very good job. And they typically are involved when there's some assets. And then if there's little or no assets, there's the Office of the State Guardian that they're more, I think they have a higher caseload and a little more difficult in terms of logistics, but those are some resources. And then senior services in DuPage County can be excellent.
So when you see an elderly person where maybe they have been the victim of financial fraud from a relative, is that a point where the public guardian might be appointed to take over?
Yes, or another relative who's not exploiting the senior citizen.
So there is.
I think that if there is and then there's some situations with big estates where it could be an institutional guardian of the estate. But in terms of guardian of the person, you start with family if possible, friend, maybe even a very close friend. And it's only when there's nobody in that situation to fit the bill do you look for somebody like look to the DuPage County Public Guardian.
Okay. Gosh, you know, and your coverage in probate court was probably an eye-opener too. I mean, can you think of any mistakes that you saw people, I guess, it goes back to the planning, right?
Well, I think that, some families have more conflict than others. And one thing I think might be a wave of the future, since we're in an age of YouTube and TikTok and whatnot, I think that videotaping the signing of estate planning documents may be a wave of the future. I think the legal profession tends to be a little bit slow, and maybe for good reason in terms of change. But certainly, and I talked to Judge Diamond, who hears the probate call currently, and he said the same thing. I think it would be helpful, particularly in cases if one child, for instance, is being excluded or disinherited, that it wasn't the product of undue influence by another one of that person's siblings, or the person making the estate plan wasn't incapacitated at the time, because sometimes the estate plan might be from 10, 20, 30 years ago, and the witnesses may be deceased, and the attorney who drafted it may be deceased or retired or can't be located. And so I think that might be a wave of the future. And if there's a person getting disinherited, or if it's a family dynamic where there's a lot of conflict and more likely to be litigation, I think those are certainly situations where you'd have to consider that.
Right. No, that makes sense. And, all those conflicts get to be pretty expensive too if they wind up being litigated.
Very much so. Very much.
Gosh, so we all know that saying that an ounce of prevention is worth a pound of cure. But, again, going back to your observations, and you're in, again, in such a unique position to see what could go better. Like, do you have any other advice for people about, what you've seen gone wrong? And again, what might be a good strategy for avoiding that?
Well, I mean, just in sometimes the most fundamental basics, like where is your will in your estate plan? You know, it's not uncommon for person passes and nobody can find the original will. And a copy of a will, it may be a little better than a copy of $100 bill, but it's not as good as the real thing. And but you'd be surprised how often it can't be found. And family members are spending tens of hours trying to find it. Because the reason the original, we're kind of a culture now where copies are as good as originals in a lot of areas. But when it comes to a will, if a person decides they don't like their will anymore and they toss it in the fireplace in the fire, or they tear it up and throw it in the garbage, that can be a legitimate reason why people can't find the original will. So whether it's by design or whether it's just an accident that it's missing, it creates a problem if you can't find it. So in years gone by, safe deposit boxes at banks were very popular. That's kind of subsided over time. And it used to be that many people had safe deposit boxes. They keep their wills, their trust documents, maybe some valuable jewelry or some other important papers that they have. And I think that, having something that's if you don't have a safe deposit box, having perhaps a fire resistant cabinet or small safe or something of that nature, and then letting the people know they're the important people, the executor, the trustee, those type of people, to know how to access them. That's just a very, very fundamental thing. And, but it's important. And then also those people being able to access your information. And that might be, because oftentimes the person is an executor or they're a trustee and they can't find things, or they were never told that they were named. That's another thing where sharing information becomes important. You really should talk to the important people in your estate plan so they have a heads up, and then that can prompt them to say, well, what do you want to do with this, and how do you want to handle this? Because there's a lot of little decisions, as we all know, with loved ones that pass. Do you want to be cremated? Do you want to be buried? Do you have a plot? Do you have any preferences to services or anything of that nature? And so, I think communication is really important.
Yeah, those are great, great tips too, that communication is a big deal. And, even first off, you're right, tell somebody where your documents are, but I was always a big believer in having notes with the documents. And I know it sounds kind of weird, but I think kids would like a letter. It sounds silly, but I think they care, something. And so with my own estate plan, I put a letter to my kids and it says, if you're reading this and I'm not dead, you're grounded. So, I'm always telling them they're grounded. They're never grounded. But anyway, but it's that, and like maybe listing out key people. Ben was probably going to cover this in his section too, but sharing that information, that's really good insight. And I didn't realize how many people couldn't actually find their documents or somebody's estate plan. That's a big deal. And
the other thing that I think is something to keep in mind is that if you just have a will, the will only takes effect upon a person passing. So it doesn't affect, for instance, we have more and more people, and in the guardianship courtroom, we had early onset dementia cases, people younger than you and I with dementia. And you need to either have a trust or you need to have a power of attorney for health care that says, if I ever am incapacitated, here's who I want to make decisions for me. And if God forbid there ever had to be a guardian, here's who I want. Because many of those cases were individuals who didn't have that, not always, but many times they were high asset people with multiple children who didn't get along. And I can recall one case where there was 8 children, and if you asked all eight of each of them what they think should be happening in terms of guardianship or both estate and for personal, you'd get 8 different answers. So if there's no guiding document, it can really create a hornet's nest that a judge ends up having to decide, and it really should be the person deciding that on the front end rather than a judge deciding it.
No, but thank God you can take on that role, though. I mean, it's you know, it's unfortunate, but somebody has to make those decisions, and you know, you'd want somebody like you with experience on the bench who can weigh all sides.
Thank you, Alice. Appreciate it.
Yeah. Well, you know, I know Ben is going to be covering some of the strategies too for how to keep people from falling into those, you know, the pitfalls that any of us could see ourselves in. But I appreciate your perspective, and we all do. And, you know, and thanks for staying on the webinar too, because I'm sure questions will come up in the end.
Oh, my pleasure. I'm glad to be
All right, but thank you. And also, now that we know what can go wrong, we have Ben Neiburger to share information about how he has helped people steer clear of those problems. And, you know, Ben, thank you for being here. This is going to be a great presentation, and the floor is now yours.
Thanks. Hello, everybody. This will be like the most boring half an hour you've ever had in your life. So be sure you get your caffeine together and sit down, and this is going to be exciting. So one of the materials that you have are a list of estate planning essentials. And these is kind of a list of 10 things that you should have just to make sure things go right. Because, you know, even though Judge Gibson is a nice jurist and his courtroom is always orderly, you know, you don't want to spend money or spend family money with the lawyers to go in front of him, because you might want the money to go to family members instead. And to deal with that, you need to have good estate planning. And it's actually kind of simple as long as you do it. So estate planning is a couple things. Estate planning is when you die, where does your stuff go? That's the first thing. Sometimes it goes through probate, which personally is my favorite thing in the world because they make lots of money doing it, but a lot of people want to avoid it. And then the next part is if you become mentally disabled, my definition, not your spouse's, and you can't express things, and you can't tell your wishes, then you're going to want to have things that allow somebody to step into your shoes to make the same decision you would make if you couldn't make it yourself. Because if you don't have these things, you go to guardianship court. And then we talk about those things that Alice and Judge Gibson were talking about, where it's the public guardian or a court guardian or something. It's a court process. Those court processes are expensive. They may be $5 grand, 10 grand, 15 grand. And if you have something with 8 children, where every time you talk to one of the 8 children, somebody says something different, most of the estates go into the lawyers. Now, us lawyers think it's great, but you may not. And if you do appropriate planning, then, you know, you can get through it. So let's talk about what happens when you die, how do assets transfer when you die, and what you can do about it. Because you heard Judge Gibson mention your will, he mentioned trust, he mentioned other things, and it's really helpful to understand these concepts by knowing what they are. And for that, we have props. I have my basket of props. You don't know what's in it, but you will soon. So when we typically do the estate planning process, we ask people how you own your assets, because there's different ways that assets transfer when somebody dies. So right here, we have our beneficiary assets. Any asset that has a beneficiary designation on the account is controlled by the beneficiary designation. So for example, if you have a life insurance policy or a 401k or a bank account or something, and there's a beneficiary on the account, that's where it goes when you die. All that happens is the beneficiary has to show up with your death certificate, wave it in front of somebody, fill out the form, and then they get it, and that's it. It's very, very easy. But the downside is if you have all of these assets all over the place and you need to change where things go, you have to change each form. Each institution has a different form. And when you're in your 50s and 60s, it might be easy to fill all these things out. But then if you're in your 80s, it gets to be hard. Now, the interesting thing about lawyers and estate planning is we make up different names for the same things to purposely confuse you, the consumer, so that you need us. So for example, on a 401k, it's called a beneficiary. On a life insurance policy, it's called a beneficiary. On a bank account, it might be called a pay on death beneficiary. And on a securities account, it may be called a transfer on death beneficiary. And those all mean the same things. It's whoever's on the form. The advantage of that type of estate planning is it's very, very easy. Fill out the form, you're done. But you can't control things after you die. I mean, how many of you have family members that you want to leave money to, but you don't quite trust that they're not going to spend it within 2 months on really flashy, fun things? So you've got to keep that in mind on whether or not they should be the beneficiary. I had one case where mom had 5 CDs, one for each of the daughters, which is great, until mom got sick and then needed long-term care. And we had to start liquidating those accounts. And whose inheritance do you want to liquidate first? Because that created a lot of excitement, both for me and for the court. And it was a great case, but could have been avoided with better estate plan. So some assets transfer through a beneficiary designation. You fill out a form, that's where it goes. It's great if you want something simple. If you have a lot of different assets this way, then it might not be a great idea. You might want to put things in a trust for control later. It's hard to change later if you can't fill out the form. So that's a beneficiary asset. All right. Then we have assets that are held in joint tenancy. So I assume that a lot of you have assets in joint tenancy with your spouse. You have a joint bank account. You own the car jointly. You own your house jointly. The beauty about joint tenancy is there it goes when you die. Whoever the survivor is shows the death certificate for everybody else who's passed, and then they get it automatically, easy peasy. This is great for the first death. In fact, beneficiary designations are great for the first death, but if it's a couple and you're dealing with the second death, these aren't the best tools. And so sometimes you want to plan ahead because maybe there's a car accident that catches both of you and your spouse if you're married, and you figured out, well, one of us dies, the other one can change things after, I'm dead. Well, what if you're both in a car accident and one's in a coma for 10 months? Well, then you're going to have probate on the second to die. So it's important to think about what you want to do on the second death if you're married when you do the planning. So joint tenancy is great. It's just as easy as beneficiary designations, except you don't have to fill out a form. You're both on the account. It's short for joint tenancy with rights of survivorship. The last one living gets it. Super simple, super easy, great for the first death, not so much for the second. The other thing that we get a lot in Judge Gibson was talking about seniors being isolated. And if they're isolated, there's a chance for financial abuse. And the easiest way to do financial abuse is being joint on an account. If child number 1 is joint on the account and all of a sudden child number 1 turns into be black sheep and does bad things, when you're joint on a bank account, you have access to the whole entire account, even though you kind of own half. That means that if the child goes rogue on you, they can take everything out of the account, go to Aruba gambling, and it's really hard to get that money back after it's put on the craps table. So if somebody is joint on your accounts, you need to be very careful that you trust this person and you continue to trust the person. I had one case that I liquidated where there was 75 grand in this account, and the daughter learned that mom changed her estate plan, so she took out the $75,000 and said, sue me to get it back. It was hard to get it back and we had to reach a settlement in a while, but it's not the greatest. If you want to have something where the child is on the joint account just for emergency purposes, just for convenience, add them as an authorized signer on the account. Just put them on the signature card. They can sign. They have a fiduciary duty not to take it. If they don't spend it, you can get it back. And then you could put a beneficiary on the account if you want it to pass easily. But you need to check very carefully if somebody's joint on an account. Alice's box lit up, so I was just wondering if she was fielding a question. If you have questions
nope.
at any time, please ask.
You just froze on my screen. You're back on again.
All right, we're unfrozen.
Yeah.
Excellent. Actually, while I was frozen, you all missed, the $1 million lottery number picked. So I'm sorry. So we have how assets transfer after death. We've got the beneficiary. We've got the joint tenancy. We talked about the pluses and the minuses of that. We also have a trust. And here is your metaphor for a trust. It's just a bowl of candy. Now, we screened everybody before you signed up, and we know that we have gold and silver and bronze assets for you. So we thought about you in advance when we did this. But a trust is simply a bowl that holds your stuff. The trustee is the one who can take out candy and put the candy in. The beneficiary, that's the one who can eat the candy. And when you hear the word trust, this is the metaphor you should think of to help understand it. There are a lot of different types of trusts, and a lot of them mean the same thing. For your purposes, for general estate planning, you just want to think of the bowl of candy. We have living trusts and revocable living trusts. Those all mean the same thing. Sometimes we call trusts inter vivos trusts because that's a Latin name for living and it sounds cool. So if you see blah, 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 blah trust, just think of this metaphor. Now, there are different trusts. We call them irrevocable trusts. Those are special things that you can't change. We also have testamentary trusts, which are created by your will, because your will is a testament. Remember Moses coming down from Mount Sinai and he has the testaments, and that's kind of where that comes from. So when you hear the word trust, all it is a bowl that holds your stuff. It doesn't do anything magic other than avoid probate on the second to die, because the trust has instructions on, if I die, please divide the stuff that's in the trust to the following people. Now, what if you have stuff as a beneficiary and you have stuff in the trust? Well, the trust doesn't control anything that's in the beneficiary box. In fact, the trust doesn't control anything that's in the joint tenancy box or container. The trust only controls things that are in the trust. So when we talk about trust funding, you have to actually put your candy in the trust. How do you put your candy in the trust? Well, with a deed or with a house, you have to have a deed. And the deed says, from me to my trust. For your account statements, for your bank account, for anything like that, you have to change the registration on the bank account from you to your trust. And you have to do this. You can't just say in the trust document, this is where it goes. So when you go to an estate planner and have a trust created, the big issue is the funding. And the attorneys will give you a flat fee for doing the trust and the will and the powers of attorney, but they're not, and maybe to do a real estate deed, but they're not going to flat fee the funding of the trust because it's a pain in the butt, because you have to call each bank, fill out a form. Sometimes you have to get a medallion signature guarantee to re-register securities. But once you have done all of this, it's like putting things in a nice, neat Tiffany box for your heirs or for the people you want to leave money to, because it's all in a nice, neat jar and it avoids the probate process. Now, we talked about assets that transfer through a beneficiary designation and assets that go through a joint tenancy, and we talked about a trust. And remember, the disadvantages of these are on the second to death, it goes through probate. Well, that's what we have now, and this is probate. Notice how I've gone through half of the Advil in the jar already. But probate's cool. Legal fees, 6 to 12 grand after you're dead to go through probate, unless you have 8 children who are fighting, and then the fees can be incredibly high, and most people want to avoid those. Now, probate's the court process that we go through to identify your assets, to collect them all together, to find out who your creditors are. Within 6 months of filing the probate and giving notice to creditors, if they don't come in within 6 months to say, you owe me money, it cuts off the creditor's claims. And then the probate process, after that 6-month creditors period is, then it distributes things to who gets it. The governing instrument, the instruction manual for the probate court is called your will. So people say, I have a will, I'm covered. Well, the will only covers the stuff that's in the probate bucket. So if you have, you know, your last friend, boyfriend, girlfriend, somebody, deceased parent or something is beneficiary on your accounts and you don't change it. And then you go on to LegalZoom to download your will to do it for yourself. Because why would I want to pay an attorney to fill out a form? And you do that and you forget about this stuff. It goes to whoever you left it on, and your will doesn't control it because you didn't put it in here. So estate planning, when estate planners ask you what your assets are, they want to find out which one of these buckets your stuff's in, because each bucket has a different set of rules. And if you think about it, the will doesn't control that much. But if you're a husband and wife and you get in that auto accident situation and each other, you're the beneficiary of it, and then you die 10 months later because you couldn't change the joint tenancy and you couldn't change the beneficiary form and anything like that, then it goes through probate. And if you go through probate, your will says where things go. If you don't have a will, the state of Illinois has made up a will for you. Isn't that exciting? Don't you all trust Illinois? This is the issue with doing these online seminars. I can't see you all nod your head about how much you trust Illinois and how you want to actually leave all of your assets to Illinois, because Illinois needs it badly. If you don't have a will, the default is half to spouse, half to kids. Sometimes that's great, sometimes it's not. So you want to change it. So there's reasons to have a will no matter what. And in addition, is when you have a will, you can say whether or not you want your executor to have a bond to go through probate to make sure they don't do anything bad, or whether you want to waive the bond, and it makes probate less expensive if you trust your executor. So when we talk about estate planning, there are several different ways that assets transfer after death. They go through a beneficiary designation, not court supervised. It just goes to persons whose name is on the beneficiary form. Sometimes it's good, sometimes it's not. You really don't want to leave a minor as a beneficiary on the account. For those of you who love your grandchildren more than your children and think you should leave things directly to your grandchildren, if you leave something to a minor and the institution that holds the asset discovers that, they are going to want you to set up a minor's guardianship to hold the money till the minor's 18, and then they're going to have a great freshman year in college. So there are different ways that assets transfer after death, and you kind of need to think through how you want to do it and then implement it, get it done. What you don't know absolutely can hurt you. Now, I want to talk about trusts a little bit more, because there's something else that trusts do other than hold your candy until you die and avoid the probate process. And for that, we have another metaphor for a trust, and that's Mr. Dinosaur. The dinosaur doesn't have a name. If you want to volunteer in the chat on a name for the dinosaur, I will adopt that for the rest of my clients. But let's say that this is a metaphor for your trust and you're single and you want to leave money to people, but you want to control it after you die. So when that happens, what you do is you have a trust inside the trust. And if you have a bunch of children, your trust can set up trust inside it. The trust document is just a little longer, or you can put that same language in a will. So instead of a 10-page will, you got a 20-page will because it's got 10 pages of this. So we have our 3 children, Mo, Larry, and Curly. And we know that Mo, Larry, and Curly, we know that they can't handle money, that they're going to spend it. And so you can have these trusts set up so that Mo, Larry, and Curly get money when they need it for their health, education, maintenance, and support. And not until they're age 35 do they get things. Or you can say if somebody is a disabled beneficiary that has special needs that need Medicaid, you can do a special needs trust. So through using a trust, you can control things after death. It's really, really handy, especially if there's minors. And that's why you want to have these things. All right, if anybody has questions, please put them in the comments, and then Alice will read them to me and I can answer them for you as I put everything away. And that's how things go when you die. You want to have that will to catch things. You want to have a trust only if you want to avoid probate. Now, my children who are in their, late teens, early 20s have caused lots of problems for me. So I definitely want my estate to go through probate to make it more difficult for them, to punish them for their teenage transgressions. But some of you may not want to do that to your children. And so you'll put things in trust to avoid probate. You'll think very carefully about the things that you put a beneficiary on, or things that are in joint tenancy for what I've discussed. The other thing is make sure everybody has access to documents. Back 30 or 40 years ago, you took the will, you hid it. You didn't want anybody to take it or abuse it or do anything with it, and so you hid the will. But now things are a little bit different with your estate planning documents, especially if there's disability or something, to avoid the court process or other things. You want to have these documents available. If you have a safe deposit box and you put things in the safe deposit box, please have somebody else that you trust on the box. Otherwise, you got to do a probate case to open the box, to have it drilled, to have the bank send the will that's in the box to the probate court for the judge to look at and deal with. And maybe you don't want that, so you want to have somebody else on the box. So that's part of why you want to have these documents. You want to have them so you know what's going to happen as things go on, and you provide clear direction. There are some cases where you want your children to handle your assets a specific way. And sometimes you can write it in the document, and in the document, you have your little subtrusts in there that force things to happen another way. We also have many different families where we use something called a moral contract. And the moral contract is unwritten. And the parent tells the children, look, after I die, I want you to do this with the family money. I don't want you to save it with your spouse. I want you to put it in a separate account and to give it to your kids when they need it, and do it informally. But if you don't do this, I will rise out of the grave and haunt your nightmares. So we have many clients that do things through guilt or a moral contract. I find in most of our families, the kids follow what's going on. So that's what happens when you die. That's why it's important to get the estate planning done. The other thing that's important is, please, even though it's easy to get a form on the internet, with estate planning, what you don't know can hurt you, and it can hurt you very bad. The other thing I want everybody to know is that the state of Illinois will soon be enacting an electronic wills statute that allows you to e-sign your will, and to do that. And this legislation is problematic because 20 years later, you've got to come back with that digital proof that you signed the will. And getting these digital keys is expensive. So if you hear something that there is an electronic will and you can sign it over the internet, I'd be very wary of that, because it's very, people have a hard enough time finding the original will, as Judge Gibson talked about. If you don't have that original will, you're toast, because it's deemed to be revoked based on his throw it in the fire analogy. And if you do an electronic will and you try to prove to the judge that it's valid, you got to bring in the electronic evidence from 20 years ago that it was electronically signed. And there's some issues with that. So I would recommend everybody sticking with paper, even if you hear that in the future, because it's very difficult to deal with that. So with estate planning, in the estate planning essentials, it's two things. When I die, where does my stuff go? How do I get it there? We've talked about that. The only thing we haven't talked about is estate taxes, and we don't really need to get to that. But the other thing that's even more important than having a will and a trust is, What happens if you become mentally disabled? If you have a stroke, or it's Alzheimer's, or a traumatic brain injury due to an auto accident, or your spouse accidentally hits you on the head with a frying pan? How do you step into the shoes and do something for somebody? And that's a huge issue, especially with the cohort that are seniors. You want to make sure that you have something that's set up where somebody you trust can step into your shoes and can make decisions for you. Otherwise, the option is an expensive court process called a guardianship. In some states, it's called a conservatorship. And in Illinois, there's two types of guardianships. Guardian of the person, that's health decisions in your body, and then guardian of the estate, which is money. And that's what Judge Gibson was talking about earlier as Alice was asking him questions. There is a corollary with what we use to control things when people are mentally disabled, and we call those powers of attorney. And there are two flavors of powers of attorney. There's a healthcare flavor, and there is a financial flavor. Now, the confusing things about powers of attorney is they're controlled by state law. And we know that state law is made up by the legislatures, which are mostly lawyers. And we talked about the theme before when we were talking about beneficiaries, which I lost my beneficiaries, where it might be a transfer on death or a beneficiary form or a pay on death. There are different names for powers of attorney, which makes it tremendously confusing. For example, in Illinois, it's called a healthcare power of attorney. Only thing in Illinois that's simple. In other states, it might be called an advance directive, a physician's directive, a medical directive, anything that sounds healthcare-ish, that's what it is. If you have one of these, the person who sees the healthcare power of attorney has to do what that power of attorney agent is what they're called, of what they want to do. If you don't have it, then we have something that's called the Healthcare Surrogacy Act that helps with these decisions. But the Healthcare Surrogacy Act pulls the power out from the family and puts it in with the physicians. It says if two physicians agree, then in these classes of people, you can follow directions. Guardian first, the spouse, and then all the siblings as a class. So if you have a fighting family and you don't have a power of attorney and they disagree, it's a big problem and you're in guardianship court and it's super expensive and not as quickly acting as you think it is. So we have a healthcare power of attorney where we appoint somebody to make healthcare decisions for you as if you could make them yourself. Now, the thing with the healthcare powers of attorney, and give me a second, I've got some questions, and let me answer these questions, so please excuse me as I look away from the screen. Mary asks, if an unmarried person with no children has no will, but owns a home in their single name, what happens to their estate? Does it go to Illinois? So as I told you in the probate process, that if you don't have a will, the state of Illinois has made a will for you. There is a whole bunch of like family trees that it goes to. It says if you're married and you don't have any kid, everything goes to the spouse. If you have a spouse and a kids, it's half the spouse and half the kids. If you don't have a spouse, it's all to children. If you don't have children, it goes to your brothers and sisters and your parents, if they're alive. If you don't have parents, just brothers and sisters. If your brothers and sisters and anybody's deceased and they have descendants, then it goes to their descendants and it gradually goes through the family tree. If we can't find any family members, then the property does something called a sheeting to the county in which you live. So, and Bill also had a question like that. What is the disposition of assets for a person with no spouse or children who does not leave a will? So I answered those questions. So I'm not great at doing the chat questions as they come up, so you'll have to excuse me. Okay, so going back to the healthcare power of attorney. So the healthcare power of attorney, somebody makes a decision for you if you can't make them yourself for healthcare. And this includes pulling the plug, removing life-sustaining treatment, doing organ donation, or as I call organ harvesting. And what you need to do is make sure that you tell your family members what your wishes are, because the worst thing that happens right at death is the children want to honor your wishes, And when they honor your wishes, they may think of something different, and then on your deathbed, they're fighting. So it's very important to tell your loved ones what you want when. Writing it all down doesn't make any difference because the hospitals aren't going to look at it. The only thing they're going to look at it is the guardianship judge if you're already in guardianship court about what your wishes are. So make sure you tell them, especially when you die, your funeral wishes, because we have a big difference as we secularize on where you want to go for a funeral. Do you want the funeral with the parade and the gold casket, or do you want to be cremated, delivered in a box, and buried in the garden? For those who want to be buried in the garden, the last thing you want is a $12,000 funeral. But some people want our Judeo-Christian funeral with all those things. Please tell your loved ones what you want so that they can do that.
Hey, Ben, there is another question in the queue about how valid or credible are the 5 wishes documents. Is that something?
I'm going to get to that in just a second, and then
Okay.
I'll answer the other questions, but thanks.
Okay.
So the thing with a healthcare power of attorney is it's a permissive document. You have the principal, the one who signs the form. You have the agent, the one who's supposed to do stuff. And the principal must follow the agent's wishes. But you have to trust the agent. So here's an example. Let's say that my wife is my agent under a healthcare power of attorney, which she is. And now we're talking theoretical. Let's say that my wife and I got into an argument. We never argue. And let's say I made her angry, because I never have ever in 30 years of being with my wife made her angry. And then we went to bed angry. And in my dismay, I knocked my hand on something and cut my finger. And then I woke up in the morning and go, oh my gosh, my finger is bleeding. I have to go to a doctor. And being an anal retentive lawyer who's also a CPA, I need to go to a surgeon. This is bad. And my wife, who's still angry at me, says, I'll go with you. Okay. So we go to the doctor and he looks at it. And of course, he's a surgeon. So what does the surgeon say? Oh, your hand's going to go gangrene. We need to amputate your thumb. And I'm like, no, it's my thumb. And my wife's first question to the doctor is, doctor, will it hurt? And so the doctor says, well, of course it will. And I'm like, well, no, don't cut off my thumb. I'm going to be okay. And my wife says, I am the power of attorney. Off with his thumb. So what really happens? Well, they have to follow me because I'm still mentally competent. Now, if my wife hit me in the head with a frying pan on the way out of the back door and I'm unconscious and I'm brought into the ER and they say, oh my God, we got to amputate his thumb. My wife says, look, I'm the power of attorney. Off with his thumb. There goes my thumb. So the lesson with that is that you need to trust your agent. You need to tell them what you want, because if you're not conscious, they can control things. Now, our question is, how valid and credible are the 5 wishes documents? The 5 wishes documents are fantastic if you have no fighting family members. Every hospital in Illinois will honor the Illinois healthcare power of attorney. They will honor that every day. Will they honor the 5 wishes? I don't know. Is it a great document that goes into more in-depth about your healthcare decisions? Yes. If you've got fighting children, is it going to help? No, it leaves out a lot. So you can use the 5 wishes, but as a guidance, I would prefer, as an attorney who does the estate planning and somebody who appears in probate court and guardianship court, to use the Illinois healthcare power of attorney, because everybody knows how that works. It has things on it. You can use the 5 wishes as general guidance to help you think through things. If you can't afford an attorney and you need something that's a Band-Aid, yeah, the 5 wishes is appropriate. So let's back up just a little bit. I've got 5 more minutes to bore you to death. But Bill had a question going back to, when I die, where does my stuff go? And he says, can a legacy to a charity be something like, if I have $500,000 or more at death, $100,000 goes to XYZ charity? And the answer is absolutely. In your will or in your trust, you can put all of those type of things. If this is the condition, then that's where it goes. You cannot do it on a beneficiary form. You can't do it with joint tenancy, but you can do it in these what we call testamentary documents in the trust and a will, and you can do all sorts of things with that. So Bill, thank you for the question. So we talked about a healthcare power of attorney, and the next thing is we talk about a financial power of attorney. In Illinois, it's known as a power of attorney for property. The power of attorney for property covers any candy that's not in your trust. If something's in your trust, the power of attorney doesn't control it. The successor trustee controls it. If it's not in the power of attorney, if it's not in a trust, then the power of attorney controls. The power of attorney allows somebody to step in your shoes and to manage your assets, write checks, get control of your checking account, pay your bills. But the agent under the power of attorney is a fiduciary and has fiduciary duties, most of which is not to steal, not to take things. The other things with powers of attorney is they're very important, because if you don't have one, the only way that you're getting access, if you're not joint on the account or not a signer on the account, is through a guardianship court order. That's the only way you do that. And those are 5, 10, 15 grand to get, or you can pay an attorney to do a power of attorney form, and then it's fine. Some people says, can I download the power of attorney form off the internet? You could. Is it going to work? Maybe, maybe not. I don't know if it's worth the bet of doing a guardianship when you can use the Illinois form. The interesting thing about the Illinois form is it has certain protections in it. Unless you say it in the form, you can't give gifts. Unless you say it in the form, you can't take somebody as a tenant off of the property. If you have it, don't have it on the form, you can't put things into a trust. You can't put your candy into the trust. So with these powers of attorney form, in your life, you may want to do some of these extra things. If you have kids, you may want to have some gifting provisions on your financial power of attorney that allows you to pay tuition or support them or something. Another reason to get some expertise when you fill these things out. Also, if you're interested in doing Medicaid planning, which my firm does a lot, which is helping the state of Illinois pay for long-term care, which is now $8,000 a month, there are Medicaid planning things that you can do, but you have to have a special power of attorney to do it in special planning in advance. Otherwise, you have to ask someone like Judge Gibson if you can do Medicaid planning, and the judge will say, well, you got to have a real good reason to do this that really benefits the person doing the gifting, or the answer is no. Versus if you come to an attorney ahead of time and understand what the person's wishes are to provide a legacy, to put things in a special needs trust for a disabled child, it helps to have those things. So as we wrap up, we talked about a couple things. Where does stuff go when you die? We talked about the beneficiary designations and the joint tenancy. We talked about why probate is awesome. We talked about trusts and how in trusts, you can have trusts that happen after you die to take care of things as you need it for the people who depend on you, or to keep them from spending your money. We also talked about that when you're mentally disabled, that you have to have these powers of attorney. If you don't have any money and you can only afford powers of attorney or a will, you're going to get the powers of attorney because those are so helpful. And also on the handout, we talked about other smart strategies and estate planning essentials. This is the document. These are my notes. And in addition to all these things that we talked about, we also had something called a HIPAA release for healthcare privacy that allows your loved ones to see your healthcare information, not just the person who is the agent under the healthcare power of attorney. We also talk on that form about keeping financial records and gift logs. If you're ever going to apply for Medicaid, Medicaid looks for the last 5 years to see if you gave any gifts away. And they also ask for all of your account statements over 5 years to prove that. So there's a lot of things that you want to keep just for those reasons. I'm going to answer one final question, and then we'll end the presentation, and we'll go on from there. And this is, how do you know if a senior citizen is mentally able to make sound decisions? Well, what if they have some dementia, but not all the time? This is where it's dicey. There are different levels of mental competence to do different things. For example, I am no longer mentally competent to do calculus, but I can balance my checkbook. And the law says that the person needs to understand what they're signing and what the effects of what they're signing are. And if somebody's iffy, you've got to be very careful on this. Sometimes you'll get a doctor's note. Are they mentally competent? Sometimes you'll go and make an appointment with a neuropsychologist who has a doctorate degree in brain studies to really determine if a person is competent to make a decision, especially when they're changing an estate plan. Because a lot of the things that we go to court for are when somebody's iffy and they sign it. And if you don't have that medical backup at the time to shore up with a professional opinion that somebody is mentally competent, there's going to be a lot of problems after that. So now I'm going to turn things over to Mike and Alice about strategies for creating a charitable legacy that is very important, both financially and both with what's in your head and the wisdom that you're leaving to your families.
Hey, Ben, that was wonderful. And I don't know when I've ever seen somebody use props during an estate planning presentation. And I swear to God, I don't remember ever laughing out loud during an estate planning presentation. So that was wonderful. And I know there's going to be more questions in the queue, and we'll circle back to those at the end.
Just so you all know, I knew some of you were laughing. Otherwise, I would have brought out the robot. So.
Well, so now moving on to a topic that is near and dear to my heart. We have Mike Sitrick from DuPage Foundation. And, you know, Mike knows the world of charitable giving better than anybody I know. And so, Mike, I'm hoping you can share, you know, a simple overview with us today about what options are available to those of us in the audience.
Thanks, Alice. And while I don't have any cool props, I do have some slides. So we'll try to up my game for future ones here. But for the last section of our program today, I'm going to talk about opportunities and strategies for creating a charitable legacy. One of my favorite parts about working at the foundation is helping people make a difference for the causes they love. And because DuPage Foundation isn't a direct service organization focused on just one cause, we're uniquely positioned to help people support a range of interests, locally and beyond, by creating a strategy that's specific to their goals. So, you know, this includes making charitable gifts during life, as well as planning for a legacy that will continue to have an impact well into the future. So why consider a charitable legacy? There are many reasons, but here are some of the most common that typically drive people. First, to ensure that the causes we love continue to achieve their missions and thrive. The second is to make a difference at a level greater than that which we're capable of during life. Most of us only have so much disposable income that we can give away each year. And we want to ensure that we have enough to take care of ourselves and for the remainder of our lives, as well as to provide for those that we care about. A legacy gift often allows us to do more. The third reason is to cement our own personal mark or to honor family members and loved ones. People are very familiar with legacy gifts and that sort of thing, scholarships, a lot of different ways to do that. The fourth is to avoid or minimize income and estate taxes for ourselves and for our heirs. And with the potential of tax reform on the horizon, this may start to play a larger role in our planning efforts. And then the fifth, you know, to help our community and to inspire others. Living in DuPage County, you can see all kinds of things that have been done for philanthropy that contribute to our quality of life. From memorial parks, you know, think of Cantini, think of St. James Farm, lots of wonderful things that were done because of people's generosity. So if you find any of these reasons resonating with you, I encourage you to spend some time thinking about them and clarifying your own goals. Now, some of you may already have a strong handle on what you wish to achieve and how you plan to go about it. And if you do, that's great. But if you don't, that's okay too. And I have some questions that may help you to jumpstart your planning. I'm not going to go through all of these, but just a couple I'm going to highlight for you. You know, first of all, what are your interests and passions? Be sure you know those. Are there causes or charities that you support now that you'd like to ensure continue benefiting after you're gone? You know, another is, you know, do you wish to involve your loved ones in philanthropy? Another are the tax considerations. Are there things that could impact the timing of your giving? And then lastly, do you or your loved ones need a stream of income? There's actually some ways to do good and get some income back. And I'm going to talk about that later on in the presentation. So once you have an idea about what you want to achieve, you can begin thinking about how to accomplish it. And there's a number of different options available to you depending on your objectives. For timing purposes today, I'm going to focus on 4 strategies that I want to make sure everybody understands. The first is direct giving, and this is probably the method that we're all most familiar with. You can make an outright gift of cash or appreciated assets to one or more charities during your lifetime. Or you can also direct a portion of your estate or other assets to one or more charities after you pass away. The second are charitable trusts, and we'll get into these in a little more detail in a few minutes, but they are trusts established for charitable purposes, which depending upon their type enjoy varying degrees of tax benefits. They require more planning, some expense to you, and often the help of an attorney to set up, but they can be excellent tools. Another vehicle is that also requires the assistance of an attorney to set up is a private foundation. These can be costly and burdensome to administer, but are essentially a charitable entity focused on accomplishing the specific goals of a person, a family, or a corporation, either through its programs or its grant making. So on a big scale level, think of the Ford Foundation or the Gates Foundation, just to name a few of those. And then lastly, my personal favorite, Community Foundation. We are a public charity where donors can contribute assets to either create custom funds or give to existing ones for the benefit of their community and favorite causes, and locally as well as beyond. DuPage Foundation, we serve donors who live and work in DuPage County, but we recognize that they have giving giving objectives beyond the county and can help them make grants throughout the nation. So obviously we have a bit of a bias here, but from our perspective, this strategy combines the best of the previous options and can generally be helpful to an individual, family, or business to accomplish their goals effectively and efficiently with the help of our knowledgeable staff. So staying with community foundations for a second, one of the key benefits of giving through a community foundation is the flexibility offered by the different types of funds. So on the screen, you'll see 4 buckets. We love that analogy. Our program head uses that all the time. But I'm going to go through 4 of those. The first is unrestricted. So if you love your community, you can make unrestricted gifts that the foundation can use to enrich the quality of life for all residents, meeting the most pressing needs affecting them. It gives us maximum flexibility to respond year to year to different needs as they arise from not-for-profits. Second are field of interest funds. Under this bucket, if you care about a particular sector like human services, the environment, the arts, or helping children and seniors, you can set up your own fund or contribute to an existing one that will provide support for groups working in that area for our community forever. Then third, we have donor advised funds. This is the fastest growing vehicle in philanthropy. If you want to be in the driver's seat of your giving and support multiple charities of your choosing on your own time frame, year to year, you can do that. You can also use it and create a charitable fund that your loved ones can continue to use into the future. And this could be a really great strategy for you if that's your goal. There's no upfront setup costs for them apart from the initial donation that you use to create. You get better tax treatment for charitable gifts than you would with a private foundation or a charitable trust generally. And you have the ability to be truly anonymous with your grant making. And then the fourth bucket are agency or designated funds. So again, if you love one or more specific not-for-profits, consider establishing a permanent endowment at the foundation that will provide a lasting stream of annual support for them. You can really think of us in this instance as kind of like your charitable trust department. We will manage that fund and ensure that your intentions are carried on into the future and really ensure good oversight. This is a great strategy, in particular if you've got smaller charities that you want to support and you're concerned about their sustainability or their ability to manage the assets. Okay, so now that we've talked about that, once you've determined your goals and a desired vehicle for your charitable legacy, the next step is to decide on the right giving strategy. So selecting the right strategy and assets to contribute can depend on a lot of factors and could really be its own presentation. But for today, we're going to focus on 5 of the most important ones. Lifetime giving of cash and appreciated assets, qualified charitable distributions from an IRA. This is a great opportunity for seniors. Bequests from a will or trust, beneficiary designations from a retirement account or insurance policy, and retained income gifts. So starting with donating cash and appreciated assets during life. If you're looking to create your charitable legacy during your life, cash is probably one of the most popular forms of outright giving, but it's not always the most tax efficient, and a lot of people don't know this. Cash gifts for people who itemize are generally deductible up to 60% of their adjusted gross income when the gifts are given to a qualified charity. However, under a special incentive created under the CARES Act for last year and this year, cash gifts to qualified charities are deductible up to 100% of people's adjusted gross incomes. Unfortunately, this excludes gifts to donor advised funds, private foundations, and supporting organizations. Now, when you don't have a weird year like 2020 or 2021, often a more optimal strategy is to consider a gift of long-term appreciated assets held for a year or more. So things like securities, so stock, mutual funds, real estate, a paid up insurance policy, closely held business interests for those of you who are business owners. These are often more advantageous because you can avoid paying capital gains tax and take an income tax deduction for the asset's full fair market value upon making the donation. And when these gifts are made to a qualified charity, these deductions are typically limited to about 30% of a donor's adjusted gross income, but there is a 5-year carry forward allowance. So next, we're going to talk about charitable, qualified charitable distributions. I mentioned this earlier. This is a great strategy for seniors if you're looking to create a permanent endowment now for your favorite causes or just really make an impactful gift. It's available for folks who are 70 and a half or older, who have qualified IRAs. 401ks do not work. You would need to transfer them into an IRA. But these allow donors to make direct gifts to charities from their IRA, tax-free. And then after age 72, donors who do this have the ability to have these gifts satisfy their required minimum distributions without having those distributions recognized as income. So under this cool strategy, you can give up to $100,000 per person or $200,000 per couple. But unfortunately, you cannot donate these to donor advised funds or private foundations. If you try to donate this to a donor advised fund, regular deductibility rules are going to apply. One other point about this that people are not quite up on generally is that with the recent passage of the Secure Act now, deductible IRA contributions who are made by individuals after the age of 70 and a half, that's going to reduce your QCD allowances year to year. So it'll be less than that $100,000. So be sure to talk to your advisors about that. Next, we're going to talk about charitable gifts through a will or trust. Ben spent a lot of time talking about wills and trusts. I'm going to focus on the charitable aspect of this. You have the ability to name charities as a primary, secondary, or contingent beneficiary of your will or trust. This is often the most common way people establish a charitable legacy. When you do this, be sure to engage an attorney to help and always be clear about your intentions. Make sure to confirm each charity's legal name, their address, any minimum gift requirement that they have for a specific purpose that you want, if there's something that you're asking the charity to do. And then also check on the feasibility of the gift that you're making to, if it's something unique. And if you're concerned about anonymity, you can ask your attorney to reach out anonymously, or you utilize a group like the Community Foundation. And I should also mention, if you're looking to provide support for future needs of your community or to assist multiple causes, or if you want a partner to assist you and your loved ones with your giving, consider using the Community Foundation by naming us as your charitable beneficiary. You can actually structure your bequests in such a way so that if you want to amend your charitable beneficiaries, you won't have to go back and update your will or trust language, but rather work directly through us at no charge. Something we like to make people aware of. So next, we're going to talk about beneficiary designations from a qualified retirement account. As with a will or trust, you can name one or more charities as a primary, secondary, or contingent beneficiary for a qualified retirement plan like an IRA or a 401k. But again, same as here, be specific about your intentions. Sometimes the beneficiary forms don't give you a ton of room, and it's important that they're correct because their terms are going to govern over your will or your trust. And then one other tip with these, consider donating these qualified retirement assets to charity first, and then non-qualified assets to your other heirs to help minimize the tax burden. The charity won't have to pay income taxes on them, and your beneficiaries will receive a step up in basis on most other assets that they receive. Okay, getting to the end here. The fourth opportunity I want to talk about are charitable gifts through life insurance. So this is, another asset you're able to use for charity. You can gift ownership of a paid up policy you no longer need and receive a tax deduction. It's essentially a gift of appreciated property. You can donate policy dividends to a charity. And you can also name a charity as a designated owner and beneficiary of a policy, and then make annual tax deductible gifts to the charity for the premiums, which the charity then pays. We have donors that are using all these strategies, and it is a great opportunity. Okay, then lastly, as we wind up here, There may be instances where you wish to be generous, but also ensure that you and your families are taken care of. In these situations, a retained income gift in the form of a gift annuity or a charitable trust might make sense. So these are just two opportunities to consider. A charitable gift annuity is actually a contract created by the donors and a charity. The donors make a charitable gift of cash or other assets. And in exchange, they or their named beneficiary receive a stream of fixed income payments back from the charity for life or a period of years. The size of the payments are going to depend upon the beneficiary's ages. It's determined by an actuarial table. And usually a portion of the gift will be, of the payment will be taxable as well as tax-free. And at the time of the donation, the donor will receive a tax deduction equal to the charitable contribution made, less the present value of the anticipated annuity payments. So if we want to get a little more complex, this one involves an attorney, a charitable remainder trust. These work similarly to a charitable gift annuity, except that the donor is establishing, again, a charitable trust now. They donate cash or property, and in exchange, again, their beneficiaries, like their children or grandchildren, will receive income or life for a set number of years. Then at the time, after that time, the residual will pass to charity. And there's two different types of these. I don't want to get too technical, but one is a charitable remainder annuity trust that gives a fixed annuity amount each year and does not allow for additional contributions. And then you have a charitable remainder unit trust, which pays an income stream based on the chosen percentage of the remainder trust by the establishing donor, and the donors can make additional contributions to this. So, and then sometimes, depending on a donor's needs and goals, it might make sense for them to have the charity benefit from the trust first, with the residual going back to the donor or the beneficiaries. That's called a charitable lead trust. So I'll leave that there, but just want you guys to be knowledgeable about some of these different options that are available. So as I wrap up here, the final piece of advice I want to share is to encourage all of you not to make these decisions on your own. There is a wealth of knowledge and resources available out there to help guide you to the right solution. And you have experts. We are so blessed in DuPage County to have a number of folks that we can call on for help, from your own personal advisors to representatives at the different charities you work with, to charitable consultants and our staff here at the foundation. Don't be afraid to use us as a team. And at the foundation, our staff can be a sounding board, help you with research and introductions to charities, and ensure your intentions are honored. So that's my time for today. Alice, I'll turn things back to you. And thanks everybody for being here.
Thanks. Let's see, start video. All right, thanks, Mike. And is our panel back? Are our panelists back? Anyway, we want to thank you all for joining us. I know we've run a little bit over and some questions have come in. So, so if people have to leave, that's understandable. But I do want to field these questions. So Ben, this one looks like it's for you. It's my brother and I thought we had worked up a good plan for my mom's care, but financially it won't work now that she's reached 100. What steps should we take now that the money to pay for her care is about to run out?
You got to call for a consultation on that one. Honestly, it can't be answered in 15 seconds. It's a 2-hour discussion.
But I mean, is there hope for somebody like that?
Maybe. It depends.
Okay.
When you deal with public benefits and Medicaid planning and long-term care planning, it is very complex and there are lots of moving pieces. And I'm sorry, I cannot summarize that. There's just too many different things that can happen.
Well, there's another question, and maybe this ties into it, but what is the typical cost for basic estate plan that covers the issues that you raised? And maybe you can throw out what the typical cost would be for Medicaid planning.
So estate planning runs between $2,300 and $5,000, depending on what's going on. It's a huge spread. It just depends on how many moving pieces you have. It doesn't necessarily depend on how much money you have, but how many pieces. In estate planning, Alice, as you remember from practice, you'd build maybe 3 different models of metaphorical houses. Mm-hmm. And it costs a lot of money to build those different models of houses, but everybody has a different amount of furniture to move into the house.
Well, how about a consultation fee? Like, what would it cost for someone to meet with you?
So we do telephone consults for free. They're short. Initial consults are $350, and we apply that towards the flat fee, whatever it is. But if you're searching for price, if you're buying attorneys for price, don't come to me. What you're buying when you go to estate planning attorneys is you're buying their knowledge. You're buying the fact that they're going to be there and they're not going to nickel and dime you to death when there's a family emergency or a document is needed or somebody that has the knowledge and background to apply the law at, to you.
Right. There's a great quote by Ben Franklin that an investment in knowledge pays the best dividends. And I guess that's how you'd look at it. You want to.
I mean, if you have a cookie cutter, estate with nothing special, go to the guy who does DUIs, real estate closings, and wills.
Mm-hmm.
It's just, and everybody's got something screwy going on.
And then another question, is there an amount at which your estate should be worth before it makes sense to create a trust?
So again, this is the unhelpful lawyer answer of it depends. Some people have just a condo that's worth 80 grand. And they really want that condo to avoid probate when they die. And the only way to do it in certain circumstances is by putting it in a trust. Some people have the same 80 grand in a passbook account with the daughter who they can trust to the end of the moon, and you just put a beneficiary on the account.
Yeah.
Some people have, $3 million with kids they can trust and nothing else. And all they got is this IRA. And the only thing you could do with the IRA is put a beneficiary on it. And they don't have a house and they rent. So it really depends. What the estate planner is doing for you is they're teaching you what you need to know so you can tell the estate planner what to do. That's what you're buying.
I get. And then Judge Gibson, one question came up that maybe you can address, and it's about digital assets. Yeah. And have you seen that play a role in when you were serving in the probate bench?
Yes, anonymous attendee asks very good questions on the written questions. I did not see that come up. So I guess a literal answer to the question, because I was thinking about it, what happens to social media accounts and other digital assets if you don't specify in your will what you want done with them? Well, if nobody's looking out for them, they sit. A Facebook account or whatever just sits there and as a quasi-active account, but hopefully nobody's posting, pretending to be the decedent. But could that be for somebody who's a influencer, a matter of litigation? Sure. Somebody who has thousands or tens of thousands or hundreds of thousands of followers, that might be a valuable asset in some respects that should be addressed in an estate plan.
Some of those social media accounts too, like I know Facebook has legacy provisions now where you can name somebody, and then, looking at like email accounts and things like that. So it varies across the board. Like I know Yahoo, I don't think will let another person in. So in some instances too, just having a password list secure somewhere, I think. That
Mike, that's a great thing. I always tell my clients, have the passwords written down somewhere, because then you don't have to deal with it. You have the passwords, you have the access. A lot of these, the digital assets, they got terms of service. And a lot of the terms of service say you just have a license while you're alive. When you're dead, it disappears. So it was a real pain, but to really find out what happens to the digital assets, you got to go dig through the terms of service for each thing that you have digital assets for. And it's awful. The best is, you have the passwords and a trusted person can go in and extract, what's appropriate at that specific time. Otherwise it gets kind of difficult.
Right. Yeah. Good question. So, well, I know we are exceeding our time, and I wanted to thank all of you for joining us today, for the audience, for the panel, the professional advisor group from DuPage Foundation who got behind this topic, which, there's so much more to talk about when it comes to seniors and, protecting that vulnerable population. So, who knows if we'll ever get a chance to do this again. There's more to talk about. But anyway, thank you all for joining us. If anybody has any philanthropic goals, DuPage Foundation is here to serve. And one of the questions that I thought would come up is, what does it cost to work with DuPage Foundation? And actually, consulting with us doesn't cost anything. It's all about providing knowledge. And then, we can point you in the right direction. And anyway, that is the sum of our webinar, and we thank you all for being here, and especially the panelists. Thank you for giving up your time and your insights and sharing that with all of us.
You're very welcome.
All right, take care, everybody. Have a nice evening.